Right, good morning, everybody. Very warm welcome to you to the Family Law Roundup April 2024. I've got 18 very interesting cases to run through with you this morning. Thanks so much to everyone I see who's already chatting away in the comments. It is great to have you all interacting and being on board as we go through the April 2024 Family Law Roundup. Before we get started, I'd like to obviously just remind you, go to www.thinklegal.coza, where you can register for events, join WhatsApp groups, and purchase resources, and also get links to view past webinars. So that's thinklegal.co.za. For those of you who have not yet picked up the case material or the course material for today, it is on our Shopify store. You can go to thinklegal.coza, take the link to our store, or you can simply follow the link which I have posted in the comments a few seconds ago. Obviously, your attendance is absolutely free of charge. It is wonderful to have you on board with us today, whether or not you purchase the course materials. The course materials are 250 Rand, and they are absolutely optional. In the course material, you get a bundle of all the cases discussed, and you get our 18-page summaries. I think it's 25 pages, in fact, this month. Summary of all of the cases, giving you a brief overview, aspects covered, the outcome of the case, and then some notable quotes for the case. Also, if you are a NABFAM mediator, we are accredited for 2 CPD points through SAM and social justice if you purchase the course pack. Please indicate clearly whether you would like a SAM or a social justice branded CPD certificate, and CPD certificates will be going out within a week of the webinar taking place. If you do not receive your CPD certificate within that time period, please do let me know, and I will help you out as far as that's concerned. So, what do we do at Think Legal? It's an initiative by Vermeulen attorneys. We aim to promote the open sharing of sound legal knowledge. While we acknowledge that the delivery of legal services is for the most part a commercial venture, we uphold the notion that legal knowledge is a public resource meant to be freely available to everyone. Due to this, we try to facilitate open dialogue and share legal knowledge among professionals. We organize a variety of activities, including management of WhatsApp groups, hosting regular webinars, and arranging social events. Please go have a look at thinklegal.coza for more information. Right, just before we get started, a very big thank you to Lawbox Practice Management Software and Vermeulen Attorneys being the two organizations that support what we do within the Think Legal initiative. Lawbox.co.za, try Lawbox free for 14 days. It is practice management software by lawyers for lawyers, and then obviously Vermeulen Attorneys for supporting what we do at Think Legal. So, as we go into the Family Law Roundup, April 2024, we have 18 very interesting cases that I'm going to be sharing with you throughout the 90 minutes that we have provisioned for this session. So, the session consists of 3 forfeiture judgments, 2 customary marriages judgments, 3 Rule 43s, quite a lot less than last month. I think last month we had about 9 Rule 43s, a whopping 5 procedure judgments, which is quite interesting, 1 care and contact, 2 contempt of court, 1 foreign marriage, which was quite interesting how the Pretoria High Court interpreted a marriage under the Matrimonial Causes Act of Zimbabwe, and then finally something you don't see very frequently, a surrogacy judgment, making 18 judgments in total. And in total, it's about 246 pages of judgments that we've summarized for you that we will be going through today. That being said, folks, just given the vast amount of information in these judgments, just a short caveat. Understand that what I'm doing here today is not trying to give you a full rundown of each case. It is simply impossible to do so. I've tried to cherry pick the main elements in each judgment and to give you an idea of where to start off when you want to interpret these judgments or read them on your own. This is certainly not case law for lazies, where you will have a full understanding of each judgment when we are done. However, you will have a good starting point, or that's my intent at least. Please tell me how I'm doing as we go along. Those watching on StreamYard, please comment as much as possible. I would love to interact with you with your comments. And also those watching on LinkedIn, you are more than welcome to post your comments as well as those who are watching on Facebook. Right, so today we are going to be starting off with the topic of forfeiture. And very interestingly, the first judgment comes all the way from Pretoria. The judgment dated 19th March 2024, although it really got into circulation within the month of April. Judge is Kubushi J. For those following along in your bundle, you can find it from page 1 to 11 of your bundle, and on your summary pages, you can find it on page 1. So, what happened in our first case, and what is the citation? TS versus MLS, and the Safley citation 2024 ZAGP PHC 289. This is from the Pretoria High Court. Now, what had happened in this case where the plaintiff TS brought proceedings against the defendant MLS, the plaintiff sought forfeiture in respect of her pension interests and her pension benefits. The parties were married in community of property. It was a long marriage since 1999. It was a 25-year marriage, and 2 major children were born of the marriage. The forfeiture was brought on several factors which the applicant, or the plaintiff in this instance, wanted the court to take into account. There was an assault case where the defendant had pleaded guilty to assault, and that was in 2006. Domestic violence during the marriage, the failure by the defendant to share his pension interests when paid out, and then finally on an extramarital relationship. Now, unfortunately, folks, what has happened with TS versus MLS is the media managed to get hold of it, and for some reason they always seem to get hold of the Pretoria judgments, and they wrote quite a few articles on how this abuser was not mulcted with a forfeiture order, or was not punished with a forfeiture order, and that was quite the tenor since that was in the media. The forfeiture claim obviously having been dismissed. So the media made a very big song and dance about how could the court dismiss this forfeiture. The defendant was found guilty of assault. Now, what we must, however, contextualize is the assault took place all the way in 2006. The divorce was only commenced, I think it was in 2019, which was approximately 13 years later. And what the court essentially found is that the abuse that was alleged took place so long ago that it could not have been seen to be the reason for the breakdown of the marriage. So what the court says here, it is plain on the evidence tendered that the order for forfeiture ought not to be granted. The marriage is of long duration, approximately 23 years, at the time of instituting the divorce. The incident of misconduct upon which plaintiff seeks to rely, that is the assault that caused the partial paralysis to her right hand, occurred in 2006, approximately 16 years before. This is quite a long time ago. Plaintiff only issued summons in 2022. Sorry, my mistake earlier, not 2019, 2022. This means that the parties had been staying together for almost 16 years before the plaintiff thought of dissolving the marriage. Plaintiff remained in a relationship with the defendant with the paralysis that she claims to have sustained as a result of the assault at all that time. The conduct of the defendant cannot be said to be the immediate cause of the breakdown. Therefore, forfeiture claim has failed in this case. Paragraph 10 is a very nice summary by Kubushi J of what the purpose is of forfeiture. It is said to be to ensure that a person does not benefit from a marriage which they have intentionally broken down. The court may order that a blameworthy party forfeit the patrimonial benefit to which he or she may be entitled by virtue of the chosen matrimonial property system. Essentially, let's go back to the framework of forfeiture. Section 9.1 says the court can or may order forfeiture if it is satisfied that one party will be unduly benefited in relation to the other, if the order is not granted. And to ascertain whether there would be undue benefit, the court looks at the duration of the marriage, substantial misconduct, or circumstances giving rise to the breakdown of the marriage. Interesting how Kibushi J interpreted this matter, decided not to give forfeiture on the basis of the alleged misconduct. And very, very interesting to see, unfortunately, how the media have portrayed the matter. So whether or not you agree with Kibushi J in terms of this judgment, please do take with a pinch of salt what we see in the media in terms of some of these judgments. Next up, we are going all the way to the Free State, and this is under the pen of Boonsire AJ. Once again, an order for forfeiture judgment landed on the 18th of March 2024. Those of you following along in your bundles, you can find it on page 12 to 30, and on your summary pages, page 2, rolling over to page 3. Full citation, NAM versus MSM 2024 ZAFSHC 97, for those of you taking notes. The facts of this matter, essentially, the plaintiff sought forfeiture of 50% of pension interests. Parties were married since 2017. The plaintiff alleged that the defendant did not contribute to the growth of the joint estate, particularly plaintiff's pension fund benefits, and that the defendant never had a fixed income or permanent employment. He continually changed jobs. He failed and or refused to financially support plaintiff or the minor daughter born of the marriage. And then the plaintiff made a very interesting allegation, a very important allegation for these purposes, that the defendant is not only currently unemployed, but also refuses to look for work. So manifestly and patently and habitually unemployed. Then, as an aside, I would also mention that the defendant, who is impugned in this instance, also sought spousal maintenance from the plaintiff, being the party that was asking for forfeiture. Now, what is interesting in NAM versus MSM is the court takes a points-based approach to the three factors in terms of forfeiture. And I'm not saying scoring points. The court essentially looked at each point individually in terms of duration, misconduct, circumstances. The court then also did a fairly good job of restating the principles set down in the Vaker judgment, which is the locus classicus really in respect of forfeiture. Now, it bears mention, obviously, since there was a claim for spousal maintenance, that the Section 7.2 of the Divorce Act factors were also looked at. In this instance, forfeiture was granted in respect of 50% of the plaintiff's pension interests. Obviously, in this instance, the spousal maintenance claim was also less than successful. And what is nice, in paragraph 65, the court sets out the principles again. What is required of the court is to consider the three issues set out in Section 9.1 in broad terms, and then to make a value judgment whether the defendant would be unduly benefited if a forfeiture order is not made. An undue benefit is one which is disturbingly unfair, and I quite like the clear enunciation of disturbingly unfair. It is something that one can really nicely use as a test in terms of argument on a forfeiture. On a careful consideration of all the facts, I came to the conclusion that the defendant would unduly benefit from the plaintiff's pension fund if forfeiture is not made in order of court. And then paragraph 58, where the court looks at the issue of spousal maintenance. From the language of the enabling provision, it's clear that the awarding post-divorce spousal maintenance is purely discretionary. The discretion of the court should be exercised judicially according to established rules of law and practice, and in making a determination of maintenance, consideration of justice must prevail. The factors that a court will take into account when awarding maintenance are not exhaustive, and the court has a very wide discretion whether or not to grant maintenance. Grant a maintenance order, the amount payable, and the duration of the maintenance. That's paragraph 58. Very importantly, folks, to juxtapose section 7.2 and section 9.1, specifically because of that issue that the factors that a court will take into account when awarding maintenance are not exhaustive. You'll note section 7.2 has a provision, any other factor. I've seen quite a lot of people plead a forfeiture, also having regard to duration, misconduct, circumstances, and any other factor. And there are, in fact, some textbooks which propose that it be pleaded that way, but that is not what the Act says. The court does not have the discretion to take into account any other factor. It is limited by the legislation at present to circumstances, misconduct, and duration. Sure, let me not fall over while I am on screen with you fine folks. This was NAM versus MSM, Bloemfontein High Court, Boonside AJ, and that is Safley reference ZAFSH C97, and that is 2024. So now moving swiftly along to the point that I just made in respect of any other factors, and this is a judgment coming from the Mafeking High Court under the pen of Hendricks JP, which is the judge president for that division. Those following along in your bundle, pages 31 to 41. You can find its summaries on page 3. And our citation, KBP versus TLP, and that is ZANWHC 105 of 2024. Now, what happened here, if I can just unlock my iPad and see what's potting. Essentially, what happened in this case, divorce, obviously, forfeiture claim in respect of pension interests. It was a marriage in community of property. And there is also an interesting point on arrears maintenance for children. So for those of you who are on the WhatsApp group, you would have heard me say yesterday that I'm quite vexed at this particular judgment of Hendricks J in terms of how forfeiture was calculated, or the court doesn't even call it forfeiture, of how the issue is calculated. And then also an issue regarding arrears maintenance, which I found very, very interesting. So what happened was that the divorce was granted by the court. The division of the joint estate was ordered, but there was an interesting order insofar as the pension interest is concerned. So one of the factors which I believe it was defendant that sought the forfeiture raised against the plaintiff was that plaintiff took out their pension fund, used it, didn't share it, and now they shouldn't be allowed to share in the pension interests of the defendant, which we are seeing, frankly, quite a lot of, at least I think 2 or 3 per month of these coming through in the unreported judgments on Safley, where the principle stands, you didn't share your bar one with me, why must you have a piece of my top deck? And what has happened to date in most of these judgments is the courts have looked at it in terms of principle. So you didn't share the bar one, which is the smaller chocolate. So let's say it's a 10,000 Rand pension, and now we're dealing with a 50,000 Rand pension. The court looked at the issue of the principle behind it. The court didn't really look at it quantitatively. And that is exactly what happened here. The court says, well, okay, the defendant is now entitled to half of the current pension of the plaintiff, which is X amount. Half share amounts to this, 103,565. It will thus be just, fair, and equitable that the amount of 463,156 be set off against the half share, and then that a division be shared. What the court also did, which was very interesting, is the court gave arrears maintenance. Now, there's no indication in this judgment that there was either an agreement, tacit or in writing, or in a court order for arrears maintenance, but the court ordered arrears maintenance for 9 years, equaling 324,000 Rand, that the the defendant would then not be entitled to claim or would had not paid, but it in essence was required to pay. Then the court issued a set-off based on these figures, and the court then says this is logical mathematics in paragraph 7, but in typical attorney fashion, I'm quite well, I wouldn't say that I'm Albert Einstein of mathematics. Let's just put it that way. But to me, this is not necessarily logical mathematics, and you can decide whether it's logical mathematics to you. But what the court then did was effect the set-off and then make an order that 50% be shared. So the effect that the court had, or the court order had, or the court effected, was that each party then got to share 50% of the other's pension interests. What is not taken into account here is the change in the value of money. So if you set off 10 Rand in 2000 money versus 10 Rand in 2024 money, it's a bit different. So very convoluted, interesting judgment, and it's very important to have a look at how the court essentially, in effecting a forfeiture, even though the court didn't call it a forfeiture, took into account this pro rata share that was set off from the claim of the pension interests at date of divorce. It remains to be seen whether other divisions are going to follow what Hendricks JP did in the matter of KBP versus TLP. And this is certainly the first instance that I've seen of where a court decided to effect a set-off in creating a 50-50 division of the pension interests rather than working merely on the principle of Party A didn't share, so why must they have a share of Party B's? So very interesting judgment, KBP versus TLP under the pen of Hendricks JP in the Mafeking High Court. This takes us on to our two customary law matters, specifically two matters dealing with the validity of customary marriages. The first is the matter of BCJ versus SJM, and this is in the Free State High Court. Judgment landed 22 March 2024, went into circulation in April. The judgment, once again, Mbele DJP, and for those following along in your bundle, page 42 to 52, summary page 5. Now, what was interesting here is there was a dispute whether there was a customary marriage between the plaintiff, who was BCG, not BCJ, and SJM, who was the defendant. The plaintiff alleged the existence of a customary marriage and said that lobola was negotiated and all the various customary rights were adhered to. The defendant, as is very common these days, denied the existence of a customary marriage, suggesting that there was no marriage contract, and also then denied that lobola negotiations occurred. What is quite interesting about this matter is that the point was raised as a special plea by the defendant, and the matter was then argued on this basis. So one of the big contentions of the defendant was that there was no lobola slip, and on that basis there is simply no valid customary marriage. The court, per Mbele DJP, quite rightly found in paragraph 28 of the judgment that a written lobola contract is not a sine qua non to a valid customary marriage. Besides, plaintiff gave a clear account of why the contract cannot be traced despite a diligent search. The defendant failed to challenge her testimony or confront her and her witnesses with a version contrary to theirs, and the court then found no reason to reject plaintiff's version. Defendant was not even able to explain why plaintiff acquired a new name, which was quite interesting, why the defendant would, in the face of that, still deny the customary marriage existed. The court then found that the essential requirements for a customary marriage under Section 3 of the Recognition of Customary Marriages Act had been adhered to, and that there was a valid customary marriage in terms of the Customary Marriages Act, and then all obligations arising from such a marriage were present. Quite interesting. I think it restates what a lot of the cases have been saying about Section 3 of the Customary Marriages Act. What I found quite interesting for use in practice is specifically that the court dealt with the issue of the lobola slip and really overtly, clearly, unequivocally made the statement that it is not a sine qua non to a valid customary marriage. So that was BCG versus SJM, and that was from the Bloemfontein High Court under the pen of Mbele DJP on 22 March 2024. Making good time so far, folks. Next up, we are going to an Mpumalanga High Court matter all the way from Mbombela, which is something that I have not seen this year yet. There's a High Court judgment from Mbombela in respect of family law matters. Now, what had happened in JE and others versus BPM, and I'll give you the citation before going into the details. That might be a bit more appropriate than just jumping in. ZAMP MBHC 29, and that is of 2024. This is under the pen of Pick AJ and then Vukeya J and Greylan Kutzer AJ concurring. Judgment dated 26 April 2024, bundle page 53 to 71, summary page 6. Now, what had happened here? It was an appeal against the lower court's judgment affirming the validity of a customary marriage between the respondent in the appeal and the deceased. The parties involved in this matter, let me get my bundle open quickly, then I'll tell you exactly who we had involved in this matter, and it's at page 53 for those of you following along in the bundle. So the appellants was the executrix of the estate was the first appellant, Minister of Home Affairs second appellant, Master of the High Court third appellant, and then a certain YBM, ABM, and BCM, which were I believe the children, I think, of the deceased, then took the respondent to the High Court on appeal, subsequent to an order by a lower court, basically finding that there was a customary marriage. So the appellants contested the validity of the marriage, arguing that there wasn't full compliance with customary practices, and they questioned the reliability of evidence regarding customary practices. Now, what is interesting is that this particular judgment goes all the way back to one of our dinosaur legislations from 1988, which was Section 1.3 of the Law of Evidence Amendment Act, the wording of which I think would certainly not pass muster in 2024, but which has not yet, at date of today's session, been repealed. In any suit or proceeding between black people who do not belong to the same tribe, the court shall not, in the absence of any agreement between them with regard to the particular system of indigenous law to be applied in such suits or proceedings, apply any system of indigenous law other than that which was in operation at the time, at the place where the defendant or respondent resides or carries on business or is employed, or if two or more different systems are in operation of that place, not being within a tribal area, the court shall not apply any such system unless it is the law of the tribe, if any, to which the defendant or the respondent belongs. So essentially the nub of this dispute was in terms of which customary rights was the marriage concluded. The court's ratio from paragraphs 35 to 36, quite a mouthful. It's clear from the Customary Marriages Act that a customary marriage must either be negotiated and entered into according to the applicable customary law, or negotiated and celebrated according to the applicable customary law. The appellant's version that lobola must be paid in full is not a validity requirement in terms of the Customary Marriages Act, nor was it, per the evidence before the court, a quo requirement of the customs or culture of Mr. M, the deceased's practice. The respondent and her witnesses' version that she was handed over and introduced to the M's, which is the family of the deceased, on the 5th of November 2007, and this concluded the marriage ceremony, stands uncontested. The judge goes further into making various findings of fact, but the nub of the matter is that the customary marriage was upheld to be valid. The appeal was dismissed with costs. However, a lot of the appeal hinged on very factual inquiries. So, one of those really factual, specific judgments regarding customary law. Interesting that it interpreted Section 1.3 of the Law of Evidence Amendment Act of 1988. That was J.E. and others versus BPM Mbombela under the hand of Pick AJ with Bukeya J and Greilenkitzer AJ concurring. Bundle page 53 to 71, and that was on 26 April 2024. Next up, folks, we're going into the realms of Rule 43. We have 3 Rule 43 matters to go through. First off, we're going to go to Pretoria, then all the way to Cape Town, and all the way back to Bloem. Those of you who know me know that I'm quite a prolix and verbose fellow, and I will very often say, I'm so sorry, I went to Bloemfontein via Cape Town from Johannesburg, and this is essentially what we are going to be doing today, except we are departing from Pretoria, which, thank goodness, is not my personal case. No offense meant to my colleagues from Pretoria. I'm seeing all of the Pretoria guys are going to drop off shortly off of the call. So first off, SS versus MC. Rule 43, maintenance for spouse and children and a contribution to costs. This was under the hand of Swanepoel J on the 26th of March 2024. Judgment found circulation within April. Safely citation ZA GPPHC 291, and that is a 2024 judgment. Bundle pages 72 to 80, summary page 8. Now, what happened in terms of SS versus MC? The applicant sought interim maintenance for herself and 3 children as follows. She wanted 9,000 Rand per month per child, 10,000 Rand per month for herself, 200,000 Rand for arrear maintenance, and then ancillary expenses for school, medical, etc. The applicant also sought relocation costs of 60,000 Rand, which she abandoned at the hearing, and a contribution to costs in an amount of 200,000 Rand. Now, what does this judgment look at? It looks at the principles related to Rule 43. What is interesting in this judgment is it looks at retrospective maintenance claims. It looks at lump sum payments under Rule 43. It looks at the inordinate delays in bringing Rule 43 proceedings, and then also unsubstantiated claims for contributions to costs. Now, what happened in this matter? There was an interim maintenance order made of 20,000 Rand per month for the applicant and the minor children. The court did not make a distinction of what portion of the maintenance is for the applicant and which part is for the children, which we know in practice can be problematic. But essentially, 3 minor children, the applicant wanted 39,000 Rand in total, being 10,000 Rand per child, and then 9,000 Rand for herself. It looks like the court followed the Solomon approach and gave her 50% of what she asked for. The ancillaries order, to a large extent, was granted in respect of medical aid and school fees, etc., as well as the respondent to pay the shortfalls. No contribution to costs was given, and no arrears maintenance was given. Now, or no, shall we say, retrospective maintenance was given. Now, what is interesting in this matter, and it's the same thing that vexed me about our Mafeking matter of, I think it was the KBP versus TLP, is the ratio of the court when talking about retrospective maintenance. Paragraph 7 of this judgment, incorrectly numbered 35. I think that was potentially just an error in uploading the judgment to Safely. But paragraph 7, incorrectly numbered 35, the court says the applicant has not provided any explanation for the delay. While the respondent would be compelled to pay all the arrears of maintenance that have accumulated up to May 2022, and consequently be saddled with a substantial liability which he cannot meet. In any event, I am not empowered under Rule 43(1)(a) to order a lump sum payment towards retrospective maintenance. Now, there are two things that I'm struggling with under this judgment, and I'd love to hear either on the WhatsApp groups or in the comments whether people agree with me or not. I'm not aware of any reason why a lump sum payment cannot be ordered by a court in terms of Rule 43(1)(a), which deals with interim maintenance. And secondly, I don't think that a court can order arrears maintenance. In this instance, there was no indication by the court that there was either an order by which gave rise to the arrears, or that there was an agreement, either tacit or verbal, in terms of the Maintenance Act, which could give rise to arrears. In this instance, the court doesn't mention anything, but essentially says the respondent would be compelled to pay all the arrears that would have accumulated. It seems to imply that there is something to this claim of retrospective maintenance. I'm not so sure about that. And I say that very, very respectfully to the judge making the order and the court. But I'm certainly not sure whether one can claim maintenance retrospectively. However, as always, I'd love to debate. I would love to learn. If anyone has any inputs, please tell me. Thanks, Karen. I see that you very bravely agree with me there. So let's move on to paragraph 9. Now, very interestingly, the court seems to, in this instance, and I didn't put it on the slide, but there is mention made of the court having to take cognizance of a document not annexed to the papers. Now, I'm going to use this in our next Western Cape decision just to talk about an issue which is quite, I would say, controversial at the moment in the difference between practices between Gauteng divisions and the Western Cape divisions in dealing with Rule 43s. But what the court here says is, in the application, the applicant has not said what the issues are likely to be between the parties. She's acknowledged the issue of PRR, of contact and care are not in dispute. She's not attached the pleadings, and the court seems to criticize her for this, but has simply said that the summons is to be found on case lines. There's no plea, and the court cannot ascertain what is and what is not in dispute. Now, obviously, folks, we know for a contribution to costs, roughly stated, you need to set out to the court what the issues are that the litigation is going to center around, what is in dispute, what is not in dispute, what have you paid to your attorney so far, what have they billed, what is outstanding, and what is your draft bill of costs going forward. None of this seems to have been done by the applicant, so quite rightly, she failed in her application for a contribution to costs. Please just put a pin in remembering that the court seems to have, in paragraph 9, where the court says the applicant has not attached the pleadings when taking a point almost against the applicant. It seems that the court puts, I wouldn't say a dim view, but the court would have liked to have the pleadings attached seems to be the implication. I suppose mediators tell me what is said, what is not said, and what is implied in this particular paragraph. But then we go on to an interesting judgment in the Cape, which is HK versus CK, and that is SAFLI ZAWCHC 99, pages 81 to 97 of your bundle, and that is Montame J, who delivered this judgment on the 10th of April of this year. Now, what is interesting in this judgment is the court references Rule 30 Cap A proceedings. Now, what the court said here, and I'm quickly going down to paragraph 82. This is a Rule 43, page 82, apologies, not paragraph 82. Introduction to the judgment, and remembering now this is in the Cape. This is a Rule 43 application where the applicant asks the respondent pays maintenance, etc., etc. Applicant further asks for certain funds to be made available. However, this relief was no longer pursued. Furthermore, the applicant did not pursue a uniform Rule 30 Cap A application to declare respondent's affidavit an irregular step and or an abuse of power. So, folks, you'll know that on the WhatsApp groups, we've been chatting quite a bit on the Clutter J judgment from the Western Cape, where essentially an applicant in a Rule 43 or one of the parts, I can't recall whether it was an applicant, tried to incorporate the financial disclosure affidavit as it is used in the Gauteng High Courts. Clutter J essentially rejected the usage of financial disclosure affidavits in Rule 43 and basically said, look, we are following the rule, we're not following the practice directive of another division. We don't think that it can usurp the role of the rules board, etc. However, towards the end of that judgment, Clutter J did mention that Rule 43 is really outdated and it is quite overdue a substantial polish and overhaul. And obviously, I'm not quoting verbatim. I doubt that is the wording used by the judge, but that was the tenor of the judgment in that instance. Now, this has precipitated a very divergent position in the Cape vis-a-vis Gauteng. In Gauteng, it seems that everything is following the line of cases that started with the Spilk J judgment quite some time back, which eventually went to the full bench, where it was essentially found that, or that was like the birthplace of the FDA, and there it was found that really the subject matter should determine the length of your affidavits, and if evidence should be put in terms of Rule 43.5, you should put it in. However, the Cape seems to be going on a much more classic view of Rule 43, where it is strictly in the form of a declaration or a plea. If you are prolix, you must ask for condonation. If you put in evidence in terms of annexures, you need to ask for permission in terms of Rule 43.5 before you put the evidence before the court, and the court must first consider whether the evidence should be taken into account. I'm seeing it quite a bit in the matters that I'm involved in the Western Cape, Cape Town, as well as the George local circuit court, that this seems to be a theme in the Cape. So for those of you who have practices spanning Gauteng and Cape Town, please take very clear note of the two divergent positions which seem to be at play over these two divisions, or these two let's call it divisions. So in the Cape, you've got the Western Cape High Court, Cape Town, and then the Northern Circuit Court, I think in Thembaletu, in Gauteng, obviously Johannesburg and Pretoria. So very interesting to see how the different divisions are dealing with Rule 43s differently. Now, what happened in the matter of HK versus CK, and sorry for the tangent, I'll put a tangent timer on next time. The Rule 43 application was brought in the context of very highly protracted and acrimonious divorce proceedings. If my memory serves, the applicant in this instance was a magistrate and the respondent was in the police or other way around. But given the tenor of the professions of the parties, one can understand that it would be quite vicious litigation. And the court made a point of what the vicious litigation was in this instance. The parties presented highly conflicting narratives about marital life, financial contributions, and behavior. And the court goes into quite a bit of detail of the history of the matter under the obviously per Montame J, going through everything. There's a lot of delving into the factual matrix of the matter. What happened in this instance is the court really made strong statements towards the needless litigation of the parties. The parties were both castigated. The court said in paragraph 35, as said earlier, this is a matter that is capable of being settled. However, the parties are hell-bent on tiring each other with litigation that is completely unnecessary. It is common cause that a claim for contribution to costs, etc., etc. But in this instance, there were a plethora of proceedings pending between the parties. In this instance, there was interim maintenance granted of 5,500 Rand per month. The applicant sought 10,200 per month, so very close to a Solomon approach here again. Contribution to costs of 125,000 Rand given, and being essentially 3/4 of the amount which was sought by the applicant, and the respondent was ordered to pay the costs. So a very interesting judgment in terms of the court's attitude in Rule 43, where there is needless litigation. In this instance, the court castigating really both parties and taking an approach of saying, well, you should have, could have settled, woulda, shoulda, coulda. Here we are now. Unfortunately, you don't want to settle, so now the courts have to deal with you. Essentially, the only position a court can take in, can adopt in those instances. And that was HK versus CK, Western Cape High Court, 99/2024 Safley reference under the pen of Montame J. Please do juxtapose this and the Kluter J judgment, which we referred to in previous roundups, with the case of SS versus MC in Pretoria, to see the divergent views of the Gauteng and Pretoria, Gauteng and Cape Town courts, not Gauteng and Pretoria. Right, so next up we're going all the way to Bloemfontein, and this is DB versus BJB, and that is Safley reference ZAFSHC, and ZAFSHC 112, 18 April 2024. As I mentioned, all the way from Bloem on 18 April 2024, and this is under the pen of Mgudlwa AJ. Short and sweet judgment, paragraph pages 98 to 102 of your bundle, page 10 on your summaries. What happened here is the applicant sought Rule 43 for monthly maintenance of 25 grand, relocation costs of 83 grand, contribution towards legal costs of 35,000 Rand, and a contribution and continuation of payments for communal property and insurance. Respondent essentially pleads poverty, citing own medical conditions and reduced income. What is interesting about DB versus BJB specifically, folks, is that there is a very clear assessment of means versus needs. And I quite like this judgment of Mgudlwa AJ. It was very concise, to the point. What I've also done, you guys will notice on my summaries for those of you who have purchased the summaries, I've started putting in on the Rule 43 cases what was asked and what was granted, because it's quite interesting to see the trends between the courts. So in this case, monthly maintenance of 25,000 Rand was sought, 10,000 Rand was given, and the respondent was ordered to pay the FNB bond. Respondent was also ordered to reinstate the insurance on the applicant's car and iPad. No contribution to costs, no contribution to relocation costs. And what the court essentially found in this instance, in taking the assessment of needs versus means, is the court was made aware of an amount of 190,000 Rand odd that was lying in a bank account of the applicant, as well as a property that she was renting out to get surplus income. And the court basically dismissed the, from my reading of the judgment, and please do differ with me if your reading of the judgment is not the same. The court essentially dismissed the contribution to costs and the relocation costs based on the fact that the applicant had these means. So what the court says, it's settled law that maintenance includes, amongst other things, the provision of accommodation, food, clothing, car, and medical expenses. The general approach that the applicant is entitled to reasonable maintenance pending finalization of divorce. However, the person claiming maintenance must establish a need to be supported. The applicant's entitlement to maintenance must be assessed having regard to the standard of living enjoyed by the party during their marriage. This should be a simple and straightforward calculation of needs and means. I really like the fact that the judge distilled it down to this. It should be a simple and straightforward calculation of needs and means. And what is the aim? The aim is to avoid substantial prejudice to either party pending divorce. It is not to provide a precise account of what is due or to or from either party according to the parties or the court's sense of morality, propriety, the blameworthiness of the parties' conduct during the marriage, or their habits of living after the separation. The case should be cast in practical rather than moralistic terms, and the emotional heat of separation should be kept out of it. For those of you drafting Rule 43s who are dealing with overly emotional and combative opponents and really inflammatory papers, beautiful dicta here by Mkhutwa AJ. The case should be cast in practical rather than moralistic terms, and the emotional heat of a separation should be kept out of it. So DB versus BJB, really a short and sweet judgment. Very, very nice reasoning, I think, by the court. And I try not to give my own comment and rather try just to give the information. But in this instance, I really do like the dictas in this short paragraph, hitting the nail on the head with approach to Rule 43. What is the purpose? What do you look at? And how should the claims be formulated? Lovely judgment all the way from Bloemfontein under the pen of Mkhutwa AJ. Right, folks, as we prepare to go into the procedure judgments, I'd like to just remind you, go to thinklegal.co.za. Please register for our events there. Join the WhatsApp groups. Purchase resources, view past webinars, WhatsApp groups. Obviously, folks, we've got the 3 WhatsApp groups, the one for event notifications in the industry, the second one being family law, and the third one being the commercial litigation and labor law. Please feel free to join us on those. I'm going to ask Nadia just to paste the links for those in the comments a little bit later on, so that you can follow them, or just check out the reminder email that went out. Cool. Moving on very swiftly to the issue of procedure. 5 judgments today. We've got essentially 1 SCA, 3 Joburgs, and 1 Pretoria. Yes, 1 SCA, 3 Joburgs, 1 Pretoria, all of them in terms of procedure. and a lot of them quite interesting. For those of you waiting for the links, you'll see Nadia has just posted them. Thank you. Love. What would I do without Nadia in my life? Right. Let's start with IBF versus ADK and another. 2024 ZAGP PHC 296 under the pen of Swanepoel J. Bundle pages 103 to 115, 22 March 2024. So, folks, I'm not going to go into the whole history of this matter. This is in the context of an extremely complex and extremely acrimonious matter involving the Hague Convention, contact and care, parenting coordination, and it's a big laundry list of issues dealt with. The matter had several court appearances. These culminated in a Rule Nisi, which was ordered on 31 August of 2023, which Rule Nisi was then confirmed in a judgment earlier this year. And this is essentially reasons for the judgment. So the background of IBF versus ADK and another, incidentally, the central authority also being cited in the judgment or in the proceedings as a party. The first judgment can also be found on SAFLI. I'm not going to go through it. That is 31 August 2023. Same case citation, just a different date. The previous judgment sets out the background. I'm going to give you a little bit of it. The applicant resides in SA with the children. The first respondent, who's the father, resides in St. Martin. And essentially, the first respondent sought the return of the children to St. Martin, and various applications, counter applications ensued. This was a family that moved around quite a lot. Mom is eventually settled in South Africa. Dad brought an application under the Hague Convention to have the children returned. In this instance, the children were not returned under the Hague Convention, and very lengthy litigation ensued. Now, why I've put this under procedure is not because I didn't know where the heck else to put it. It's because there are a couple of very interesting procedural questions in this matter. The reasons for judgment given by Swanepoel J in this instance related to punitive costs given, as well as why the respondent's application for a postponement was dismissed, and why the Rule Nisi in terms of the August order was confirmed. Now, what does this judgment look at in terms of the procedural? It looks at the conduct of legal practitioners in correspondence. The court says, the court makes very, very strong findings in terms of the tenor of the correspondence by the father's attorneys. For example, in paragraph 5, in my view, urgent application was a clear abuse of process. It was launched in the most urgent of timelines, some 8 days after the applicant had requested details of the holidays. Urgency was not specifically dealt with as required, nor do I believe the application was urgent at all. Furthermore, the request by the applicant for an itinerary was reasonable, and had the first respondent acted in a more conciliatory manner, the application may not have been necessary at all. I intend to express my displeasure for the respondent's conduct. There are quite a few other paragraphs in the judgment also castigating the tenor of the correspondence. Then, in finalizing the Rule Nisi, I'm going to just look at paragraph right at the bottom. My apologies, it's cut off a wee bit on my slides there, but it's a very, very long quote. Paragraph 19. The court essentially says, overall, the children seem to be settled in their current home and school, and it is my view in their best interest to have certainty as to their circumstances. For that reason, I intend to confirm the rule NISI. However, going forward, there should be an assessment of all the parties to establish what interventions may be necessary to assist the parties and the children to stabilize their relationships. Very interesting that the court gave clear indication of the assessments required. Grand. Moving on, LM versus MM, and I'm going to start speeding up. We've got 30 minutes left, and we've still got another 2, 4, 6, 8, 9 judgments to get through. So let's start making hay while the sun is shining. So LM versus MM, ZAGP, Johannesburg High Court 325, Norco J and Opperman and Wilson J concurring, 28 March 2024, bundle page 116 to 132, summary page 13. Now, this was an interesting matter. The judgment is against a Rule 42.1, which was a variation of a court order. Essentially, what happened is the parties were divorced. They agreed that the accrual would be divided. There would be an accrual payout. The original order determined the accrual to be 3.03 million odd. Then the respondent in this appeal went and had a crack at amending the order based on what they say were alleged errors in valuation and calculations. This was heard by Meyer Frawley J, and the amount was amended to 5.5 million, a good 2.3 bar extra in terms of the accrual payment. The appellant challenges the amendment or the variation which was granted, saying that it improperly alters the substance of the initial judgment, and that the party who was claiming the accrual wanted the increase or the variation should have proceeded on an appeal. The appeal was dismissed. The court essentially found that Rule 42.1b was applicable, process was followed correctly, and the accrual amount was rectified. For 2.5 bar, can we expect these parties to go to the SCA? Potentially. Let's watch this space. The ratio of the court, paragraph 48, the rectification does not take away the substance of the judgment, as the amounts are derived from the evidence and the record before the court, bearing in mind, as stated in West Rand Estate case, that the addition of interest erroneously omitted could be added in terms of Rule 42.1. As such, in this case, the value of the remainder of the party's assets as captured in Mr. Getz's report was left out. This was not adding extrinsic evidence to contradict, vary, or qualify the judgment. It was extrinsic evidence the appellant referred to, where it was held that if there is any uncertainty in extrinsic circumstances leading up to the court's granting an order may be investigated and regarded it in order to clarify it. Based on the foregoing, it follows that the court did not err in its adjudication. It is tried that the appeal court may interfere with the judgment of the court where it has been demonstrated that the court has misdirected itself. So the court did not misdirect himself according to the full bench, and the appeal was then found to be meritless. So can you change an accrual amount once you have ascertained the true state of affairs? Yes, absolutely. Next up, MR versus LO. I'm speeding up a little bit more. Maintenance writ, whether to issue out of the Magistrates Court or the High Court. Joburg matter, 16 April 2024, ZAGP JHC 371. This is before Green AJ, and bundle pages 133 to 140, summary page 14. The applicant wanted to set aside a writ for unpaid maintenance, and the core of the applicant's application was that the respondent should have issued the writ out of the Magistrates Court and not the High Court. The argument did not hold much water. And essentially, the nub of the issue is right there at the bottom. In my view, once it is accepted that a party has an election, there logically cannot be circumstances where that election must be exercised in a particular way. If that were the case, the party would not have an election, but would instead be required to go to one or other court without a choice. The applicant in this instance said that the maintenance court was better suited, essentially, for the writ. Court rejected that argument and said, look, the respondent has an election. Go to the magistrates court or go to the high court. You can choose. Very simple, clear, crisp principle in MR versus LO and others. HJ versus PJ. This is from the Supreme Court of Appeal. This went all the way from the regional court, and it's interesting to track its progress through the courts. And essentially what happened here was, in a regional court divorce, the court had compelled one of the parties to provide further particulars for purposes of trial. The matter was taken on appeal to the High Court. The High Court says, no, regional court was wrong in giving this order, and I'm setting it aside. The unsuccessful party in the High Court then went to the SCA. The SCA then basically exonerated the appellant to the SCA and said the judgment of the magistrates court in granting the order to compel further particulars was not a final order and is therefore not capable of appeal. But the SCA then also gives reasons why it entertained the appeal from the High Court, delving into declarations of rights and final orders versus interim orders. Very interesting. And in my haste, I've not given you the full citation, and I do apologize. HJ versus PJ, ZACA 55, and that is 2024, 19 April. This judgment landed. It was under the pen of Kwele J.A. with Nichols, Hughes, Mayer, and Mbele concurring. That is bundle pages 210 to 219 and summary page 16. I think it settles a very clear question, which I think we know the answer to as attorneys and advocates. A application to compel or an order to compel is an interlocutory application. It's not a final order, and it is not capable of being taken on appeal. Next up, LR versus TS, all the way from the South Gauteng High Court. This is Safley reference ZAGPJHC 336, and this is before Wadi AJ. This arises out of the uncontested divorce court, or the unopposed divorce role. What had happened? Plaintiff sought divorce, who was in Australia during the service of the summons. The summons was served at the defendant's place of employment and was not served personally. Plaintiff then proceeded to set down the matter on the unopposed role. Defendant's attorneys got wind of the issue and essentially obviously contested that the summons was served properly, and the court quite rightly said divorce summons needs to be served personally. That much is very, very clear in terms of legislation. Matter was removed from the role. Plaintiff was ordered to pay the costs of the removal. As an aside, the court had some things to say about the supervision of the candidate attorney, but I'm not going to go into that today. So that is LR versus TS, cautionary tale regarding personal service of divorce summons from the South Gauteng High Court under the pen of Wadi AJ. Next up, we have a mere one care and contact matter, but it is quite a doozy, so let's get into it. The matter is TH versus CH, all the way from the Western Cape High Court, ZAWCHC 100, 2024, Safley reference, under the pen of Nziweni J. judgment landed 9 April 2024, can be found in your bundle, pages 220 to 246. So for those of you who are in the bundle, please forgive the jump. I had a little bit of an issue with my Adobe getting all the judgments compiled, and this one had to slot in right at the end. That's page 19 on your summaries bundle. So essentially, it was an application regarding PRR in terms of the TH, who's the applicant, the father, and CH, the respondent mother, post-divorce. There were concerns centering around the mother's ability to act in the best interest of the child due to temperament, substance abuse, and alleged physical and emotional abuse of the child. Expert reports were taken into account. There was I believe it was a clinical psychologist or a psychologist certainly, who evaluated did the assessment. The court evaluated their reports. What was interesting here, if my memory serves, the primary residence was with mom post-divorce. That got flipped around after an incident of abuse towards the child, and now this matter then eventually reached the High Court after an investigation. What was interesting in this judgment, what you need to be aware of, is the court looked at 4 different phases of phased-in contact as recommended by the investigator. It's interesting to see how those aspects were formulated by the court. And the court then obviously, as in all cases with kids, looked at Section 7 of the Children's Act and Section 28(2) of the Constitution, which are our go-tos when talking about best interests of the child. What is interesting, paragraph 23, it's tried that although parental rights are expressly protected in the Children's Act, they are not by any stretch of the imagination absolute. I find it interesting, this wording. I don't think it's wrong per se, but parental rights are expressly protected in the Children's Act. Now, in South Africa, we do not distinguish between parental responsibilities and rights. That is one parcel. As an interesting aside, in jurisdictions like Scotland, for example, you have parental rights under one section of legislation, parental responsibilities under a different section. In South Africa, we make no distinction. So speaking about parental rights without using the full term parental responsibilities and rights feels a bit strange. And it's interesting that the court talks about these rights being expressly protected. I think they are specifically defined in Section 18.2 or Section 18, Section 18.2 and Section 1.1 in terms of the definitions. But I think the exercise vis-a-vis the child is much more of a child-centric approach than simply the parties' rights being protected. I'd love to hear your comments on that. However, very sound judgment by Nziweni J in terms of the outcome, where he says a proven failure by a parent to manifest willingness and ability to act in the best interest of the child may lead to termination or limitation. What happened here? There was phased-in contact that was ordered, safeguards implemented in terms of drug tests, etc. for mom. Parenting coordinator was appointed, and each party was ordered to pay their own costs. So, folks, final stretch today. We've got 4 more judgments to go: 2 contempt of court, 1 foreign marriage, and closing off with the surrogacy matter from the SCA. This, however, was TH versus CH, ZA, Western Cape High Court 100 and 2024, and that is Safley reference under the pen of Nziweni AJ on 9 April 2024. Then we go into the extremely interesting and extremely contentious realm of contempt of court. Starting us off, MF versus VF and others, and this is from the South Gauteng High Court. This is a post-divorce scuffle or skirmish in terms of alleged non-adherence by one party to the terms of the settlement agreement. This was under the pen of Bishop AJ on 2nd April 2024, bundle pages 155 to 168, and summary page 21. Now, what happened here? The applicant sought a court order to declare respondent, his ex-wife, in contempt for failing to comply with a divorce settlement going back as far as July 2005. The agreement involved the management and eventual sale of a property which was held in a trust, of which, very importantly, applicant and respondent were both trustees. The applicant's claims centered around the respondent's alleged non-compliance with the terms regarding the sale of the property. The judgment discusses the obligation of trustees under the settlement agreement, the evidence required to provide contempt, and the appropriate legal remedies available. So, what is interesting about this judgment is that the court doesn't say that the applicant is without remedy. The court says essentially that he chose the incorrect remedy. The application was dismissed and each party was ordered to pay their own costs. The court made certain statements regarding the conduct of the parties as trustees. The court appearing in this instance, if you read the judgment, quite sympathetic towards the applicant, understanding his frustration. The application, you'll notice MF versus VF and others, was also in terms of the respondent being cited in her official capacity as a trustee of the trust. The court had quite a lot to say in this and is saying you can't just cite one trustee, you've got to cite all of them. Secondly, there's no indication that he as trustee tried to call a meeting of trustees to try to take a resolution. So essentially the court says, unfortunately for Mr., he has misconstrued his legal position and remedies in this application. He cannot seek to hold just Mrs. in contempt as one of the trustees of the trust. Either all of the trustees, which includes himself, are in contempt, or none of them are. Since there is no indication that he has attempted to call a meeting, he is every bit as much to blame for the predicament he finds himself in as is Mrs. F. Essentially, the court saying this is not a contempt of court matter. This is a matter under the Trust Property Control Act and the terms of the trust deed. Avail yourself of your remedies available in that instance. So in MF versus VF and others, ZAGPJHC 318 under the pen of Bishop AJ, contempt of court not proven in this instance. However, next up, we're going down to Bloom, where contempt of court was proven. And this is something that we don't really see very often. Now, the matter HAE versus HSE, ZAFSHC 114, 2024, you can find it in your bundle 1692184 under the pen of Zitzman AJ on 25 April 2024, still a very fresh judgment, summary page 2020. Summary page 20, not 2022. Sure, that would have taken a while. Now, what is interesting about this matter is the court's reasoning in coming to the conclusion that there was a willful and malified disobedience of the court order. Now, the proceedings arose due to failure to pay maintenance post-divorce and a failure to satisfy costs orders that the respondent was aware of. Guys, following in the notes, you'll see that I made a note there. There's a long procedural history of applications and counter applications, not relevant. I'm going to skim over those. I'm only going to go into the contempt proceedings. So applicant seeks to hold respondent in contempt for failure to comply with divorce order. Respondent pleads poverty, as is always the case. At the time of the hearing, the respondent had approached the maintenance courts for a reduction. Those proceedings not yet finalized. But very interesting on the factual matrix. The respondent came to court and said, look, my only source of income is from a trust. I am the sole beneficiary of the trust. However, I'm also one of the trustees of the trust with two co-trustees, one of which is my mom. I get an amount of 6,000 Rand a month from this trust. I cannot pay maintenance. The court then essentially looked at the financial position, and what came out was that in 2019, the respondent loaned an amount of nearly 2 million Rand to the trust, which was an interest-free loan payable upon demand. obviously, which was a in arm's length transaction. So the court looks at the requirements for contempt of court. A distinction was drawn between the purpose of contempt of court and maintenance court, and this is paragraphs 44 to 45. Interesting, go have a look at that. The respondent, in opposing the application for contempt, took the point that this should go to the maintenance court, and the court said no. Contempt is to vindicate the sanctity of the court granting the order. Maintenance court is to establish quantum, etc., etc. So we are here to ascertain whether you are guilty of contempt of court. There's an interesting discussion on the interplay of the finances of a trust and a maintenance debtor, and then also quite a lot to be said regarding failure to make a full and frank disclosure. Right. In this instance, contempt application granted. Respondent fined 50,000 Rand. Furthermore, committed to 6 months direct imprisonment, suspended on condition that he comply with his maintenance applications and pay arrears of, I think it was about 250,000 Rand. What was the clincher for the court in this instance? The fact that the respondent has been in continuous contempt since December 2019 speaks volumes of his disregard for the integrity and authority of the court. So, conduct of the respondent so egregious that the court said, not only am I giving imprisonment suspended on condition that you pay, but I'm also making you pay 50,000 Rand fine, and I'm going to hurt your pocket where it's going to hurt you the most. 2 more to go, 9 minutes left. I'm going to run through them very quickly. Foreign marriages up next. SH versus SH. That is Pretoria High Court, 17 April. Malatsi Tefo AJ, bundle page 185 to 194. And that is ZAGP PHC 365, Pretoria High Court. Now, what happened here was there was a uncontested divorce which proceeded in terms of the marriage laws of Zimbabwe, which, as we know, is the Matrimonial Causes Act in Zimbabwe, section 7.1 and 7.4. Now, the Zim law follows to a large extent the UK position in terms of redistribution orders for a marriage which is essentially out of community of property, but those provisions actually make it in community of property. Question, is it lawful to make a loan on a trust? Yes, certainly you can loan to or from a trust. If you're talking about an attorney's trust account, potentially a different situation, but yes, it's lawful. But it must be well documented. It must be a legitimate business transaction. You need to have proper resolutions, etc., etc. It cannot be done in a malified way. So this matter, SH versus SH, moving swiftly along, was marred by procedural complexities, including defendant's failed attempt to reintroduce a previously struck out defense and the subsequent withdrawal of an intention to defend, accompanied by a signed but later contested settlement agreement. Respondent or defendant conduct left obviously quite a lot to be desired, and the court then eventually got fed up and proceeded with the matter on an unopposed basis. In this matter, judgment or divorce was then granted on an unopposed basis, and the orders were granted in terms of section 7.1 and 7.4 of the Matrimonial Causes Act of Zimbabwe. Interesting to see how our court looked at the Zimbabwean law and interpreted it, founding jurisdiction in terms of section 2.1a of the Divorce Act, as well as looking at section 4 of the Divorce Act for the irretrievable breakdown of the marriage. Now, I'm not going to go into the quotes. I'm going to go into our surrogacy matter, just in the interests of releasing all of my esteemed friends and colleagues back into the wild at 10:30, as I promised to do. Please feel free to have a look at the quotes that are in your summaries. For those of you who have not yet picked up the summaries, please do visit our Shopify store and go and check out the summaries. $250 gets you all of the case law discussed, all of my summaries, which essentially look like this in a very handy format for you to see exactly what transpired in each case. And if you are a SARM or social justice member under the NABFAM Board of Mediators, then you can get yourself two delicious CPD points, two juicy CPD points towards your re-accreditation. So I've posted that link for you. Last up, we go all the way to the SCA in terms of a matter where the position was settled in terms of AB and another versus Minister of Social Development under or heard in the Constitutional Court. And what happened here was it was a matter where two parties essentially approached the court and they wanted to have a surrogacy agreement registered so that they could go through the surrogacy process. What happened here was the court had to deal with whether there had to be a biological link between one of the commissioning parents and the gamete which is used in terms of the surrogacy arrangement. Now, Section 294 of the Children's Act says that it must be the gametes from both parents, or if that's not possible, one of the parents that must be used in terms of the pregnancy, so that there must be a genetic link between one of the parents and the child. The parties approached the court to say that this is unconstitutional because there is now a position where they want to do a surrogacy using essentially the same DNA material as one of the children, so that the child to be born would have a genetic link with its sibling and not with one of the commissioning parents. The SCA basically dismissed the appeal and said, look, it is constitutional because there is an imperative. As mentioned, the text and context reveal the purpose. It is to protect the child to be born by creating and establishing a genetic origin of a child to at least one of the parents, which is important for self-identity. The SCA under the pen of Mokotloa J.A. with Motle Mabindla Bukwana and Koile J.J.A. concurring. And this is, I'm so sorry I didn't give you the citation, KB and another versus Minister of Social Development. You can all hear the fatigue coming into my voice and my brain at this point in the proceedings. ZASCA 54, 19 April 2024. The provisions of Section 294 of the Children's Act being found to be constitutionally sound. So that's it for the Family Law Roundup, April 2024. My reminder, please go and have a look at thinklegal.coza. Join our WhatsApp groups, register for events, purchase resources, and view past webinars. For those of you who haven't picked up the course material, please feel free to do so. Huge thank you to our supporting companies. And from my side, a very, very special thank you to all of you who have taken an hour and a half out of your busy schedules to listen to me ramble and prattle on about what's new in the world of family law. Thank you to everyone who has supported us by purchasing our course bundles for use in your practice. You enable me and Nadia to do this in addition to what we do in terms of the legal practice. So I do thank all of you for being here today. Thank you for buying the course pack for those of you who did buy, and I look forward to seeing all of you on WhatsApp. So folks, have a phenomenal weekend, and I will see you next month for the May Family Law Roundup, which will be taking place on the first Friday in June, which I believe is the 7th of June, if you would like to pencil that in so long. So from me, Mervyn, and from Nadia, wish you all a lovely weekend. Thank you for watching, and we will see you next time. And I will be ending the stream in 5, 4, 3, 2, 1. Cheers.